Hello, everyone, and welcome to this Fox Nation special Trump on Trial live show. I'm your host, Greg Jarrett. Thanks for being with us. We are nearing the very end of the weeks-long case against former President Donald Trump inside a Manhattan courtroom. Closing arguments wrapping up any moment now as both sides make their final pitch to the jury before deliberations begin tomorrow. So the question is, what's been going on with both the prosecution and the defense? How did they do in their summations? And what will happen in the end? Trump is expected to speak on his way out of the courthouse. We'll take you there live if he does. But first, joining me now to weigh in on all of this is criminal defense attorney Brian Claypool. You know, Brian, what about that? Joe makes a great point. The O.J. case, which I covered from inside the courtroom for 9 months, was a classic example of jury nullification. The evidence of his guilt was overwhelming. It was compelling. There was no question about it. The jury said, I don't care about the law. We have the power to nullify the law and acquit. In this particular case, it could be sort of just the opposite version of jury nullification. There's no evidence of guilt, but we're going to nullify the law by finding him guilty. That's a real possibility here, isn't it?
Hey, Greg, great to see you. Yeah, I was on your show last week and I mentioned that. In fact, I think that's all this case is about. The prosecutors knew going into this case that they had no bona fide, tangible, reliable, credible evidence to tie former President Trump to falsifying financials, let alone with an intent to interfere with the election. So what they did is they aligned with the judge that allowed it to engage in character assassination for 3 to 4 weeks. And they just threw everything out there on the planet up against the wall, with the Stormy Daniels, with how they had a sexual encounter, what they were wearing, the Access Hollywood tape, all of that having nothing to do with proving up this case. But it served one purpose, to Joe's point, to get 12 people back there when this is over and hate former President Trump so much. They'll despise him so much that they'll just find a way to declare him guilty, even though, as we sit here today, there's still not a single shred of any evidence to support a conviction.
Brian, I thought one of the things that worked effectively for the defense is that Todd Blanche methodically went through the lies of Michael Cohen. We're not talking about the lies to the banks, the FEC, the lies to Congress, the lies to the IRS, the lies to the judges in courtrooms. I mean, the list goes on and on. You need a calculator to keep track. No, what he did was he looked those jurors in the face and he said, he lied to you. Not once, not twice. He lied to you 12 different times. And then he bullet pointed those lies to the jurors in the courtroom during the testimony of Michael Cohen and laid it out for them. I thought that was an exceptional use of closing arguments by the defense. What say you?
Yeah, Greg, great point. I've done a lot of closing arguments, and what jurors like to hear are numbers, right? For example, I sue the county here a lot on social services cases where kids are murdered, right? We go after DCFS and we say, you didn't follow mandatory duties, right? So when we get into closing argument, what we do is we say what Todd Blanche did. You breached 7 mandatory duties, for example. Here are the 7 breaches, just like Todd Blanche did there. Jurors absolutely love that. Why? Because that gives them, if Todd Blanche said 12 times Cohen lied, that gives jurors 12 single opportunities of reasonable doubt. I would have gone one step further and said, hey, we only need 1 for reasonable doubt. We've got 12. This is overwhelming. You've got to get an acquittal. One other point I wanted to make, Greg, good thing there's an instruction by the judge, right, that says that closing arguments are not evidence, because the prosecution is creating fiction. They are making things up in this closing argument, saying things like we don't need Michael Cohen, saying that we have overwhelming evidence of Trump falsifying financials. They are simply trying to turn this trial into their testimony, the lawyer's testimony in the courtroom, as the evidence. And I'm really hopeful that this jury can look beyond this obfuscation of the real truth.
Brian, I got to think that if there is a hung jury, defendants and their lawyers often consider that to be a victory because, for example, in the Bob Menendez case, they threw in the towel and decided not to recharge. They waited several years and caught him with his pants down and gold bars and all sorts of things. And now different, additional, more powerful charges against him. What's the answer to Katie's question?
Yeah, well, unfortunately, we're not dealing with prosecutors who have dignity, common sense, integrity, right? Because that's what an objective prosecutor would do. Hey, we tried this case for 4 or 5 weeks. We got a hung jury. Let's say there is a hung jury. We got a hung jury. There's a presidential election. Let's let this go, right? But I highly doubt that's going to be the case. Alvin Bragg could care less what people think about him if he tries this case again. And I wanted to make one comment on De Niro, on De Niro's comment too, Greg.
Sure.
And by the way, I'm very humble, but I mentioned this gloat phrase on Outnumbered last week with Harris Faulkner. So do I get one gold star for that? I hope. But
all the credit.
But look,
you do.
Hey, Greg, who's the gloat now? Is the gloat Michael Cohen, or is it Robert De Niro by saying what Joe said, that we're going to lose all of our civil liberties if Trump is elected? I think there's a tight race between the two of them now.
Yeah, and the records violations, according to the indictment, happened in 2017. How do you unduly influence an election the year after the election is over? Under the doctrine of factual impossibility, that is literally impossible. But the judge, Brian, has made an astonishing ruling in jury instructions. And I double-checked with one of the lawyers today, and he said, yep, it's true. The judge is going to instruct the jurors that as to the secondary crime, it doesn't need to be unanimous among the jurors. Now, wait a minute. The U.S. Supreme Court long ago held that every aspect, every issue in a criminal case has to be unanimous. That includes all the essential elements of a crime. They have to be 12-0. And yet this judge is tossing out due process rights under the 14th Amendment by depriving Trump of that Supreme Court endorsed right. How can this be?
Yeah, Greg, this is, I hate to give away my age, but you remember that show, I Dream of Jeannie? I don't know if you remember that show.
Yeah.
She winkles her nose and then
who could forget
just
Barbara
makes things
Eden
happen or makes things go away.
Larry Hagman,
remember
right?
that show?
Larry
Yeah,
Hagman, J.R.
it's
Ewing,
like-
right? Wasn't he on there?
Yeah, exactly. Yeah,
Larry
it's
Hagman.
like that's what this judge is doing. He's like just twinkling his nose, and he's like, "Oh, okay, let's get rid of the U.S. Constitution. Let's change it from anonymous to like 9 out of 12. I think that'll do, right? Hey, let's winkle our nose and let's say, oh, it doesn't matter. There's a federal election law, even though we're in state court, and the state court has no jurisdiction over a federal law violation, right? I mean, this is just catastrophic. I think that, at the end of this case, if, in the unlikely event Trump is convicted, this is a poster child case for an appeal.
Oh, yeah. But, just set the record straight. Twitching the nose was Samantha Stevens in Bewitched. Barbara Eden
my
in
God,
I
that's
Dream
right.
of Jeannie. She nodded her
Oh my
head
God,
like
that's
that.
right.
And, folded her arms.
Thank you.
But
Now that's a fact check.
But I was in
Wow.
love with both of them, so it doesn't really matter. All right, final thoughts. We got a couple of minutes left.
Maybe a different judge.
Yeah, Greg, he would be the same trial judge, and this could go.
Yeah.
I think realistically, if it's a hung jury, you're looking at maybe 4 to 6 weeks. You're not looking at a couple of weeks because the judge has to deal with other things. But if I might mention, I think the percentages Joe had mentioned what Jonathan Turley said. I would lower the 85 to 75 on a hung jury, and I think there's more likely like a 20% chance of an acquittal. Now, why?
Wow.
Because of the point you made, Greg. If these jurors catch on to what the prosecutors, remember what the prosecutor said, we don't need Michael Cohen. They brought in this pathological liar for 3 or 4 days and then they betrayed the trust of the jury, said we didn't really need this guy, that could lead to more jurors now shifting over to an acquittal. And then my final point is the failure to call, I think his name Keith Schilling, the security guard who was in on that phone call, the failure to call him on the stand, I think is just absolutely devastating to the prosecution. If they wanted the truth, they would have brought him in to talk about that phone call. They didn't.
Yeah, Keith Schiller as well as Alan Weisselberg, key witnesses to prove the prosecution's case, which the prosecution chose not to call. And again, I think you're right, Brian. If they're paying attention, they got a big question mark. What are you hiding from us? And jurors don't like stuff hidden from them by the prosecution. Brian, you guys are excellent. Thanks for taking the time to join us today. And thank you all to our viewers for watching Trump on Trial live show.